Welcome, Your Honors, litigators, and legal professionals. I am absolutely thrilled to present this explainer today. We're essentially creating a definitive bench manual for evaluating behavioral evidence in economic damages. We are going to explore a framework that fundamentally shifts how we understand consumer choices in legal disputes. We're moving away from those rigid, often disconnected statistics and moving toward actual, real-world human behavior.
Okay, let's just quickly review the docket for this explainer. We'll be covering 1. Beyond simple regression. 2. Unpacking the funnel. 3. Causality and antitrust. 4. Consumer protection versus IP. 5. Assessing damages. And finally, 6. The litigation checklist. So, starting with Section 1, Beyond simple regression analysis. Why single variable models fail in court.
Now, when litigators bring an economic expert to the stand, a lot of times those experts rely entirely on simple regression to prove a direct link between a business's action and a market outcome. But I want to pose this rather provocative question to the judges evaluating this kind of evidence. Does a single variable truly capture a consumer's choice? Treating a purchase as a single discrete decision, just a simple dot on a graph, completely ignores the incredibly complex, layered reality of how humans actually make decisions.
Think about it this way. Regression assumes this perfectly flat, direct link. For example, it might argue that simply adding a rounded corner to a smartphone's design automatically equals a guaranteed $100 increase in value. But the purchase funnel, it maps a series of psychological hurdles. It asks the critical question, did that rounded corner even get the consumer's attention in the very first place? It reveals the nuanced, iterative reality from the absolute first advertisement all the way to the moment a consumer finally pulls out their wallet.
Let's move to Section 2, Unpacking the Purchase Funnel, the 4 hurdles of consumer decision-making.
Believe it or not, this core framework actually dates all the way back to 1898. It was introduced by an advertising executive named E. St. Elmo Lewis. Yet, well over a century later, it remains absolutely crucial for modern judicial decision-making. The modern consumer buying path maps out 4 very specific hurdles: awareness, consideration, conversion, and post-purchase. And what's absolutely vital for the court to understand here is that consumers inevitably drop off at each and every one of these phases before a final purchase is ever made. You just cannot assume that a consumer who simply becomes aware of a product is automatically going to convert into a sale.
So why does this matter so deeply for the trier of fact? Well, the purchase funnel translates our intuitive, everyday shopping habits into a highly formal, rigorous structure for evaluating complex market data. It gives the court a truly practical lens to assess whether a defendant's actions actually cause the economic harm being claimed.
Which brings us to Section 3, Causality in Antitrust Cases, Understanding Monopoly through Market Behavior.
Let's apply this framework directly to understanding monopoly behavior, and to do that, we'll look back at the infamous Department of Justice antitrust case against Microsoft during the browser wars. Let's just neutrally lay out the facts of the timeline. In 1994, Netscape launched the first commercial web browser. By 1995, Microsoft began bundling Internet Explorer for free with its Windows operating system. And to put that into perspective, by 1997, only 18% of U.S. households even had Internet access. Finally, by 2003, a settlement was reached in the Netscape versus Microsoft litigation.
Now, analyzing this from an expert behavioral perspective, Microsoft's bundling strategy fundamentally disrupted the purchase funnel. By putting Internet Explorer directly on the desktop, they bypassed the awareness stage completely for new users. Pre-installation literally eliminated any need for consideration of alternatives like Netscape. And because it was already sitting right there with zero switching costs, it artificially forced conversion. Consumers never even had to be aware of Netscape, completely short-circuiting those first 2 crucial steps of the funnel.
And what was the result of that disruption? Internet Explorer reached a staggering 95% market share by 2003. Now, this number isn't just an isolated statistic. It represents the absolute endpoint of a disrupted behavioral funnel, where consumer choice was effectively bypassed altogether.
Moving right along to Section 4, Consumer Protection versus IP, tracing the timeline of harm.
Shifting gears a bit, let's trace the timeline of harm across different areas of law, because the exact stage of the funnel where the alleged harm occurs makes all the difference in the world. In consumer protection cases, like the Yogi Kombucha class action, the focus is almost entirely on alleged deception during those early awareness and consideration stages. But if you look at intellectual property disputes, like Apple versus Samsung, the focus shifts heavily to the late stages, really asking whether those infringing design features actually drove the final conversion.
Let's look a little closer at that Yogi Kombucha case.
Plaintiffs there argued the label organic kombucha deceived consumers because the dry tea bags didn't contain live organisms. But, tea is a low-involvement purchase. People do very little research when grabbing tea off a shelf. Furthermore, consumers entered the funnel with vastly different levels of awareness. Some actually knew what kombucha was, while others just thought the box looked nice in the aisle. They also had totally divergent consideration sets, comparing it to either hot teas or refrigerated health drinks. Because of this massive variation in consumer awareness, proving a uniform class of harmed individuals becomes a total legal nightmare.
All right, Section 5, Assessing Damages and Intent. Quantifying post-purchase lock-in. When we move into how the post-purchase phase is absolutely critical for accurately assessing economic damages, the source material explicitly warns us. An expert opinion exclusively based on regression analysis may incorrectly infer a causal link between the at-issue conduct and the endpoint. Let's translate that into plain English. Basically, assuming a specific feature, like the rounded corners of a smartphone or a tap-to-zoom function, directly caused a multi-$100 sale without actually testing the conversion funnel can wildly inflate your damage calculations.
To truly understand damages here, we have to define network effects. This is a context where a good or service offers increasing benefits the more users it actually has. In the Apple versus Samsung dispute, if an allegedly infringing feature successfully drove an initial sale, it meant more users on that platform. And that led app developers to flock to that platform, creating this massive positive feedback loop that compounds initial conversion into future market dominance.
And closely related to that is the installed base effect. This is the incredible power of post-purchase lock-in. Once a consumer buys a phone, they learn the new operating system, they buy all the new chargers, they transfer their photos, the cost of switching just becomes way too high. Therefore, an infringing feature that captures a consumer at the conversion stage inflates damages immensely over time, simply because that consumer is now locked in for future upgrades.
Because of this massive downstream value, assessing real damages requires absolute precision. Experts have got to use conjoint surveys at the conversion stage that reflect the actual purchase process. And crucially, they must test non-infringing features, things like battery life, processor speed, and GPS, against the infringing features. Why? To prove the consumer actually intended to buy the phone for the patented design and not just because it had a great battery.
Finally, Section 6, the Litigation Verification Checklist. Actionable steps for counsel.
This is where the theory becomes highly practical for litigators aiming to challenge simple regression. Counsel must subpoena specific behavioral data at every single phase of the funnel. For awareness, you want to analyze social media to see if the infringing feature was even mentioned. For consideration, you got to evaluate Google Search Analytics and A/B ad testing. For conversion, demand intent surveys that isolate the specific claims. And for post-purchase, perform text analysis on online reviews to literally prove or disprove actual consumer confusion.
So, to summarize our entire explainer today, by explicitly considering human behavior at every stage of the funnel, the court totally avoids the dangerous pitfalls of a rigid, endpoint-focused approach. The purchase funnel bridges the gap between those purely mathematical, statistical models and the messy, nuanced reality of how humans actually make their decisions.
I'll leave you with this final, provocative thought. As you sit on the bench or as you prepare for your next big trial, ask yourself, how will you evaluate the true causal narrative behind your next damages expert's regression model? Demand deeper behavioral evidence. Demand the funnel. Thank you so much for joining me for this explainer.